afternoon, everyone. Thanks for joining us today for Immigration 101 for employers. We're so excited to have Hannah Little here to kind of talk through this with us. I'm Dr. Shannon Cook, VP of Human Capital here at Dominion Payroll, and I'm thrilled to be joined today by Hannah Little, Managing Partner at Garfinkel Immigration Law. Before we get started, just a quick note that today's webinar is being recorded and you will receive a copy afterward. If you have questions for Hannah, feel free to drop them in the questions chat and we'll be happy to address as many as we can during the Q&A session at the end. And before we get started, just as a background, Hannah brings a wealth of expertise in immigration law, particularly in the preparation of non-immigrant work visas and employment-based green card petitions. She assists companies and individuals with applications based on extraordinary ability, multinational management, and national interest waiver, and more. She's widely recognized for her work, including an AV Preeminent peer review rating and listing the best lawyers in America and Chambers USA. Beyond her legal work, Hannah is also deeply committed to pro bono representation and serves as the vice chair of the AILA Innovation and Tech Committee. We are honored to have you with us today, Hannah. Welcome.
Thank you so much, Shayna. I'm excited to be here. And we have a ton to cover in 30 minutes, so I'm going to jump right in. But I love talking about immigration, look forward to sharing some of my world with you, and hopefully it resonates with some of you in your day-to-day. So just briefly, Shayna mentioned I am managing partner at Garfinkel Immigration Law Firm. We are physically located in Charlotte, North Carolina, but represent, of course, employers really all over the country and around the world in a wide variety of industries. I have been in practice since 2006 and am a state board certified immigration law specialist. I was just telling Shayna before we got started, I am a true immigration nerd and love the topic. It's what I've dedicated my career to, and it really is fascinating. Just a reminder, of course, that this is an informational presentation and should not be considered legal advice. Happy to chat with folks, offline if there is a specific concern. And with that, what I hope to cover today, and again, this is a lot, but I want to talk about your non-immigrant or temporary visas, primarily the work visas. I want to touch on your DACA and your TPS employees because that's top of mind right now for a lot of employers, as well as the employment-based green card practice and some general tips on compliance and best practices for HR. Before we start, I think it's probably worthwhile to talk about who are the government agencies that are involved. There's a lot of acronyms and kind of an alphabet soup, really, when you're talking about immigration law. Primarily, us as business immigration attorneys and you as HR professionals will have the most contact with the U.S. Citizenship and Immigration Services. They are the arm of the Department of Homeland Security that adjudicates visa benefits, as well as green cards and citizenship applications. However, it's important to note that there are quite a few visas, as well as the employment-based green card, that require interaction with the DOL, and we'll talk more about that later on. If your employee is outside the U.S. and applying for a visa or has obtained a visa status here in the U.S. but is traveling and needs a visa stamp to re-enter, then the Department of State and the U.S. embassies and consulates would handle that particular application. ICE is the last one that's involved, hopefully not too closely, but they are the interior arm of enforcement, and that includes audits of I-9 and issues around compliance there. Another thing I'll say about our country's immigration system is that it's primarily based in statute. So these are laws written by Congress, and that many of them are decades old. There is some shift and there's a dynamic nature to my practice based on which administration is in office and sort of what policies are articulated in the regulations or even just in the U.S. CIS policy manual. But there are certain things about the infrastructure that can't change and haven't changed in many years. A lot of those are around the allocation of visa numbers, both for the H-1Bs and for green cards. And we'll talk a little bit about that later. You can really put our work into kind of two buckets. We're either working towards a temporary, a non-immigrant visa, or an immigrant visa. And when I say immigrant visa, that's really used interchangeably with green card or permanent resident status. I warned you, alphabet soup. So it really does span kind of almost the whole alphabet in terms of the number of visas out there. But I think these are the ones that you're most likely to come across in your day-to-day, or if you're managing an international workforce. I threw the B visitor up there because there's a big red flag in terms of sometimes folks come as a business visitor and erroneously start working, which is a big no-no. So in most cases, so know that the B oftentimes does not allow for employment authorization. So if you've got someone here as a business visitor, don't let them work or put them on your payroll. Other ones, of course, are students who are in F1 status, most professional level positions, the H-1B, Ls for intercompany transfers. We've also got our TNs for Canadians and Mexicans under what was formerly known as NAFTA. Our extraordinary ability folks are under the O1. And then we've got NASCAR here in Charlotte. So we do some number of P visas for athletes and entertainers, which are always fun. So this chart here is just to show you that within these non-immigrant or temporary work visas, there's a lot of variation in terms of each one has its own eligibility criteria. Each one is available for a different duration. And when we look at the duration of a visa and we're strategizing with our clients, we look at two things in terms of determining what's the best fit. We look at what the initial grant is. So for example, an H-1B can be granted for up to 3 years initially. But we also look at the max. So some visas only can be extended for a certain number of times. And so, for example, an H-1B, the max is 6 years unless they're at certain points in the green card process. So those are things to keep in mind and that we need to be monitoring as your immigration counsel in terms of advising on the next steps. Another thing that's really important to the employee in many instances is these work visas come with dependent visas for their spouse and minor children. And some of them would allow their spouse to work, others will not. And that can make, of course, a big difference to a family and can often be part of the discussion in determining what's the best fit. I'm spending some time on F1 students because for many employers, this is the entry point for sponsoring someone for an international work visa. And the way it usually happens is this. Our F1 students are granted up to a year of employment authorization after they graduate under what's called OPT or optional practical training. They get a work permit card, an EAD, and show up and apply for a job. At that point, there's no immediate action required from an employer. They can hire them without sponsoring them for a work visa. But when that EAD expires, in many cases, the only way they can stay on is if the employer does sponsor them for the relevant work visa. And so I'll note here too that there's an additional 2 years available, so a total of 3 years of employment authorization for certain F1 students who have graduated from a U.S. Institution with a STEM, science, technology, engineering, math degree. And you'll see this theme kind of run throughout, particularly under this administration, and that there is a high preference for recruiting those STEM workers who are working in STEM fields. I mentioned the EAD, and I thought it'd be helpful just to throw up a visual here of what an EAD or a work permit looks like. They aren't unique to F1s. They can be used for a variety of different statuses, your TPS folks, DACA, folks who have a pending green card, asylees. This right here, this category tells us, where they fall under the regulations, how they were issued that EAD. But I think for you as the employer, the important thing to know is that it is limited in terms of its validity. And so it does trigger that requirement to track for re-verification for I-9 purposes, of course. And it may, depending on what the underlying status is, may lead to future discussions about employer sponsorship for a more stabilized status. Moving into work visas. So these are the non-immigrant or temporary visas. They are always employer specific. So that worker is tied to you unless they can find another employer who may be willing to take over that visa sponsorship process. I think it's important to note here that some of the visa categories define employer very narrowly as the payroll entity down to the EIN. So if you're in an organization that's shuffling folks around and you've got folks on a visa status, that's a good time to talk to your immigration lawyer, because even though it might all be under the same umbrella, this may trigger a requirement for an amendment in order to stay compliant. Many of them, same, maybe position and location specific. So if there's going to be a change there, again, that should trigger a call to immigration counsel. The other thing I think it's worth mentioning is that, surprise, the government doesn't move very quickly. So there's a planning element involved. It's important to keep in mind that the processing times for these are often 3 to 6 months or longer, depending on what's going on. You can, for most of these, pay for expedited adjudication, so 15 business days for a little over $2,800 to the government, in addition to the other standard filing fees. The H-1B, I think that's the one that shows up the most often in the news, or those of you who have worked with an international workforce are probably very familiar with the H-1B. On the one hand, it can be a great tool. It captures sort of all of these professional level positions. The minimum requirements for an H-1B are that it is for specialty occupation positions, which means a minimum of a U.S. bachelor's degree or its equivalent in a related field. It's granted in 3-year increments. I talked about that earlier. Maxes out at 6, but can be extended beyond that based on certain milestones in the green card process, which for some folks is critical because the green card process can take many years. The downside, and this is a big one to the H-1B, is that it is limited by statute each fiscal year for brand new first-time H-1B applicants. There are only 85,000 total available H-1B visas, and 20,000 of those are limited to folks with a U.S. master's degree or higher. So historically, the demand has far exceeded the supply, and I threw up the numbers here from this last fiscal year. There were almost 500,000 employers, who registered for these available 85,000 slots. So the government's response has been to implement a lottery system to select who gets to even submit the H-1B petition to be considered for approval or not. And that happens every year in March. Typically, the filing period is through the end of June, and the start date is the beginning of the next fiscal year, October 1. Also important to note with the H-1B is that there is a wage requirement, and this is one of the visa categories that interacts with the Department of Labor because of that wage requirement. I think of an H-1B as a last resort because, for somebody who's never held one before, because the lottery system can be so frustrating. So I always vet other options, and the O-1 can be one of those other options. It's been referred to in the news as the Einstein visa, but the standard is not quite that high. Really, if you can't demonstrate that you've won a Nobel Prize, which most of our folks can't, I've done one in my 18 years of practice that was a Nobel Prize recipient. Then the regulations list sort of a number of criteria that you can piece together. And if you can demonstrate at least 3, then you may be eligible for the O1. And those are things like scholarly publications, major media about your work or you, being employed in a critical capacity, higher level of remuneration, original contributions, and so on. So this really can be a great tool for your superstars, for those who really are at the top of their field. And I'll note here that under this administration, USCIS has stated in its policy manual that there is a preference for those who are doing this type of work in the STEM fields. So again, it can be a great tool for those critical workers. Moving quickly, there may be additional options for you if you are a global organization with branches around the world, or if you are majority foreign owned and it happens to be with a country that the US has a treaty with, which the list is pretty long. It's most of Europe and a bunch of other countries. So those are things worth exploring with your immigration counsel. Sometimes if you're a global organization and you've got a key employee that's missed the H-1B cap, you can create a visa opportunity if there is a way to assign them abroad for a year for one of your other global organizations in one of these critical roles. So important to know about those as well. And then lastly, I think it's also important to note that there are certain visas available, for certain nationalities. So, Australians have a visa option, Chile, Singapore, I mentioned Canada and Mexico. And not only are they not, subject to this lottery system or the caps, but they're oftentimes way more streamlined. You can go directly to DOS rather than having to go through the petition process with USCIS. And before we move on to the employment-based green card, I did want to touch on DACA and TPS, because a lot of these folks are key members at this point of our workforce, and their status is in flux. Again, this is one of those categories that's really at the discretion of the current administration. And so I bring these up to mention that they're here in a quasi status, right? They've been, for the deferred action for childhood arrivals, basically they've been granted permission to be here. They get this employment authorization they can renew every couple years. It's been in existence since 2012. And then the temporary protected status is very similar in terms of what the actual status is, but it's really based on country conditions, determination that these folks can't go back to their home country for a myriad of reasons. And I bring these up only to mention that there may be an employment-based green card option if you are interested in stabilizing their status. I think that the DACA holders probably have the cleanest path because so many of them were brought here as children. So there's not, there's a lower instance of sort of prior immigration violations or things that might stand in the way. But it is worth going through that assessment if it's something you're interested in doing for these employees and want to make sure that you don't lose them based on losing their employment authorization. I would caution to make sure you have a detailed discussion with your immigration attorney, make sure they undergo a detailed assessment before making any commitments or promises to go through this process. All right, green cards. Again, here's big picture. There's really 5 ways in our system that you can get to a green card or permanent status here in the US. I'm going to talk briefly about employment-based, everything you need to know in 10 minutes. The employment-based system is one of these, again, set up on a statute. It's set up on a quota system. So the law has divided positions up into 5 different categories. What you will probably be dealing with most in the employment-based sponsorship space are these first 3. The EB-4 is really religious workers. EB-5 are for investors. But this quota system basically says within these 5 categories, we are granting a certain number of green cards per category, per country of birth, each fiscal year. And when we hit that number, we're going to stop giving out green cards until the next fiscal year. So what has that done with countries with a high influx of workers here is created an enormous backlog, particularly for India. And again, I know this chart makes your eyes cross, but this is published. I only put it up here to show you that you have some workers who have started the green card process a decade ago and still aren't able to apply for the green card. And that's one of the reasons the H-1B can be so important, because it does allow them to continue to extend their status and work here while they're waiting to be able to apply for a green card. So you can see here, C means current. So most countries for priority workers are current. But if you're from India and you're in the EB2 category, so these are professional level positions. These are positions that require an advanced degree. If you started this process sometime in 2012, you are now eligible just now, this month in 2024, to apply for your green card. The green card for most employment-based categories is a 3-step process, and this is primarily the EB2 and the EB3. There's a labor certification. That's an application with the Department of Labor, also called PERM. 2 is the employment-based immigrant visa petition that you as the employer then file with U.S. Citizenship and Immigration Services. And then 3 is the green card application. So that's really focused on the employee and are they eligible and admissible to the U.S. And again, for some, this step 3 takes years to come. The labor certification meets the requirement for these EB2 and EB3 roles that there are no qualified and available U.S. workers for the position. So you as the employer are required to demonstrate that through a labor market test that is dictated by Department of Labor regulations. It's going to feel very outside your normal course of business in some ways, because the methods of recruitment, the timeline of recruitment, the reasons that are lawful to disqualify a U.S. candidate are all dictated by these Department of Labor regulations. And some of them are way outdated. I mean, one of the required methods of recruitment are newspaper advertisements, 2 newspaper advertisements in the Sunday newspaper in the area of employment. So I don't know if any of you still get the Sunday paper, but if you look at the ads, I always take a look to see, because I bet at this point, at least 95% of them probably are for this PERM process, and it's probably a big moneymaker for the newspapers. But it's important to note that that there are certain immovable timelines here. This process can take a long time because you must go through the steps as dictated by the Department of Labor. There's no premium processing or way to expedite it. So that's really important from a planning perspective for you and your employees. And these are the folks I just mentioned who must go through the labor certification process. It's this some of the EB2 category if it's based on an advanced degree professional role, and then EB3, which are all your other professionals and your skilled and unskilled workers. There are categories that get to bypass the labor certification, and these are your EB1, and that's your outstanding professors and researchers, extraordinary ability, that's sort of the green card parallel to the O1 visa we talked about, and your international managers and executives, and that's sort of a parallel to the L1 for intracompany transfers that we talked about as well. They get to go directly to step 2. And file the I-140 petition without having to demonstrate that they have looked for qualified and available U.S. workers. There's also a subset under EB2 for national interest waivers. So essentially demonstrating that, and this can be a self-petition by your employee as well. It does not require employer sponsorship, but essentially that it is in the national interest because their work has national importance, and they are well positioned to continue it, to bypass the labor certification and go directly to the I-140. And again, I will say right now, the current administration has said we favor those with advanced degrees in STEM fields who are pursuing a career in one of these critical and emerging technologies as articulated by the White House. So there's a lot of great opportunity there for folks who are in STEM fields or have STEM workers. The filing date of the perm, if it's required, is the priority date. So that's the place in line. We saw that visa bulletin, with the 2012 numbers. Those folks have that established priority date from, again, the date of filing of the perm. If you're in one of the categories that gets to bypass perm, then your place in line or your priority date is set by the filing of step 2, the I-140 petition. As an employer, I think it's also important to note that once the perm or the labor certification is certified by the DOL, you have a filing window in which to get step 2 filed. It's 180 days, plenty of time, but it's something to be aware of because you've gone through a lot of work and time to get to that perm certification. So you don't want to lose that just because there wasn't a timely filing of the I-140 petition. And then step 3 is the green card application. And again, that's really focused on the employee and showing that they are qualified and eligible for a green card, no criminal history, immigration violations. They've got to go to a medical exam. And once they become green card holders, once this application is approved, in most instances, they are eligible to apply for U.S. citizenship if they wish after 5 years of being in green card status. There is no requirement to apply for citizenship. They can certainly hold that green card status for as long as they'd like. So practical tips. What is your role as an HR professional in managing an international workforce? I think it's important to note we work closely with a lot of HR professionals. You are often the sole person who is paying attention to this. You are often the only person who's really advocating and minding these employees with visas. And that's really important on a number of levels for compliance. It's, for re-verification for I-9, making sure expiration dates and everything else are being kept up with. And then, making sure that you're aware or there's awareness around notifying you when there's a material change to their position that could trigger a need to file an amended visa petition. And then I think, again, a lot of this burden, if you've got a good immigration counsel, should be handled by your immigration team. But be proactive. Don't sit, on an issue or a question. Make sure you're reaching out to the experts and asking the question. And, they should be helping you strategize and plan ahead as much as possible because the U.S. government, again, does not move quickly. And so you want to make sure that you're working around that. A lot of times, one of the services we offer is assessing potential hires, whether or not it leads to a case. Again, you want to make sure you know what you're walking into. So if your talent acquisition team has a question, make sure you're reaching out and getting help from the experts. When you're recruiting, and again, this is if you have a separate talent and acquisition team, this is really making sure that they're well trained. It is, of course, permissible to ask your job applicants if they have the legal right to work here and if they require visa sponsorship now or in the future. But the key thing here is that you have to be asking all of your job applicants the same questions. You can't make that call and start asking the question just because of someone's name or the way they speak or their appearance. It has to be across the board and be consistent. You can't ask for documents until after a job offer has been extended. And you, of course, hopefully are all aware of this as HR professionals, can't tell them which documents to give you. Both of these issues could open you and the organization up to, document abuse and discrimination claims. So make sure you're keeping your team educated on being consistent and doing the same thing across the board. I think another thing to be aware of with visa folks is, again, can you tell that I try to get my HR folks to call me every time there's a change? Because I'll say it again. There's a change. Call your immigration attorney if there's a change in any sort of job duties, position, or the conditions around employment. Be aware that some visas have requirements around termination, and make sure even if you're terminating for cause, that you're consulting with your HR, with your immigration counsel, and some have document retention requirements. And I've run out of time, but this is my last slide. Just make sure you're conducting regular audits, setting up alerts, use E-Verify. In most cases, it's a great tool. Be consistent and call your immigration attorney. And that's it.
Amazing. That is a lot, Hannah. Thank you so much. I know how hard it is to fit all of that in 30 minutes. Thank you for that sort of high-level overview for us and also for our partners on the call. We did have two quick questions come through that I'd love to run by you really quickly. We have a question from Dorothy. She says, we employed international students working at the church and had to refund Medicare and Social Security that had been taken out because she did not realize they should not have been deducted. She says, I know now, but is this a general rule when you're dealing with international hires?
It is not a general rule with international hires, but it is a rule for students. They're FICA exempt, and a lot of employers run into the opposite issue where they may have an F1 who they weren't getting that withheld, and then they switched to H1 and didn't make the right switch in their system, so had an unhappy employee who had a big chunk taken out later.
Yeah.
So yes, you did the right thing if it came to your attention and it was refunded, and that is true for F1 students.
Okay, awesome. Thank you. And then we have a question from Alex who says, what is a resident card as compared to a green card? Are they the same or different?
It's the same. Yeah, they're used interchangeably.
Okay. And then finally, we have several contract workers. What questions should we ask their employer to verify immigration status?
So contractors basically you are charged with, I would ask the contractor, in terms of whatever your service agreement with them, to make sure that they have attested that they're providing folks that are legally authorized to work. And then at that point, if you have no reason to suspect that they're not being honest or that those folks aren't authorized to work, then you've protected yourself. But if you are still held liable if you have constructive or actual knowledge that something's not quite right here. Do be careful there, but I would work with the contracting agency first.
Yeah. Okay, and we just have one more slip in, and then I promise we're done here. Andrea says, is it possible to change the status for an affirmative asylum petitionary? Question mark. That was my question.
Yeah, so that's a little bit more nuanced and would be very fact specific. And I will, in full transparency, we don't handle many asylum cases, but any sort of change of status sort of requires an assessment of underlying status for the individual and sort of what their immigration history is. So I would encourage you to talk to somebody in your area who has expertise in that area, and I can certainly pass on referrals if I do happen to know anyone.
Great. Okay, I think that's it. Thank you again for your time today. That was a really informative, some good questions asked. So a lot of investment in the participants as well. So thank you, Hannah. And then, of course, your contact information is on here if anybody wants to reach out and maybe get some more information or work with you moving forward with their own employment immigration work.
Yeah, thanks so much. It was my pleasure. Thanks.
Thank you. Have a wonderful day.
You too.